Hi, this is Scott Pierce. Today's seminar covers civil procedure. And if you're doing these seminars in the order I recommend, this is our first seminar together outside of the multi-state subjects. And as you'll see, it gets an awful lot easier starting right now. Civil procedure has a lot fewer issues in it than any of the other topics that we've seen so far. Furthermore, over and over again, the bar examiners test the same issues in the same way. And I think we can break civil procedure down into two broad categories: jurisdiction and everything else. Basically, jurisdiction is the name of the game here. You'll see, and I'll show you, that they test the entire outline of civil procedure, and it's important to understand how the subject is constructed, and there's a fair amount of law you need to know. So let's take a look at the approach that I present, and you'll see I summarize things pretty concisely. Take a look at the section on jurisdiction, and think about jurisdiction for a moment. The examiners can test us on two broad categories: federal and state jurisdiction, and they do it over and over again. You have to know how they test it, and you've got to have a clear idea of what the law is in order to answer. Fortunately, it's all pretty simple. So let's begin with state jurisdiction. State jurisdiction breaks down into two categories: the traditional approach and the modern approach. The traditional approach basically relies on the physical presence of the defendant within the jurisdiction. But the modern approach is more flexible and easy to apply for essay purposes. The modern approach to jurisdiction is found in International Shoe and the other cases that flow from it. Basically, you've got to have a long-arm statute plus minimum contacts. And minimum contacts is an analysis that breaks down into sections. And as you'll see, as usual on the essays, our job is to spot the issue, break it up into pieces, and then connect the facts from the pattern to the pieces of law. So for minimum contacts, there are three links in the chain: purposeful availment, foreseeability, and fairness. Once again, you're going to get an awful lot more points explaining what the facts in the pattern are and how they fit into this analysis than you're going to get from putting a lot of boilerplate into your answer, where you recite the structure of the analysis. Use the structure as a structure, and then focus your attention on the actual factual analysis. That's where the points are, here as elsewhere. Federal jurisdiction is the other broad category of jurisdiction on Civ Pro questions. Here we've got territorial and subject matter federal jurisdiction. Also, venue arises in this context. Actually, venue can come up in state jurisdiction also, but typically it's more commonly tested in federal civil jurisdiction. Finally, we get to Erie, the case that deals with the choice of law in diversity cases. So obviously we've got to know about diversity jurisdiction in the federal court system too. But ultimately, the application of Erie is the choice of law in diversity cases. So I will show you how Erie is tested. Here again, it is tested very ritualistically. It isn't a hard issue to spot if you're looking for it, and it isn't a hard issue to analyze. There's also one or two black letter law items that you really need to know. By the time you're done with this seminar, you're going to know them. So that's jurisdiction, and that's the bulk of the issues in civil procedure. And to my way of thinking, they're also the most complicated. Next, we move on to pleadings. Here, it's just the nuts and bolts of litigation, either in federal or state court. And here, it seems to me evident that over the years, problems involving pleadings are far more common on the performance examination, where they have to give you the law, or in crossover questions involving torts or contracts or real property. And by the time you're done with the crossover section in this series of seminars, you'll see a little bit about just how civil procedure can be crossed over into any subject involving litigation between people that are not in criminal court, civil litigation. Also, motions for summary judgment are commonly tested on the performance examination and on crossover essay questions. Certainly, they can arise on Civ Pro essays too. Next, we turn to discovery. Here again, in our experience, discovery has come up an awful lot more on the performance test than it has on the essays. Still, it's worth being aware of the basic devices of discovery. I list them for you, and it's well worth your time to be acquainted with all of them if your experience up to now has not included them. Remember that the limits to discovery are a part of the law of evidence, privilege, and finally I talk about motions to compel and sanctions for noncompliance. I do think it's worth pausing here for just a moment to consider just how inextricably connected civil procedure and the law of evidence are. These two subjects have an awful lot of threads that link them together, and here the idea of privileges is just one of them. Next, we consider issues of trial and appeal. Here again, this is somewhat more common on the performance exam than on the essays. But still, we've already seen issues in evidence dealing with the relative role of judge and jury. And here in civil procedure, the issue of jury trials can come up again, and it has on the essays more than once in the last 15 or 20 years. Next, we consider appeal. And here, the key point, really the only point that they test on the essays over the years, is the final judgment rule. If you don't have a final judgment on the merits, you really don't have anything to appeal. Sure, it's possible that an interlocutory appeal issue could come up, but if it did, it would be just about the first time. Finally, the last pocket area of civil procedure is really second only to jurisdiction in terms of importance, past adjudication. These issues also are tested repeatedly, really over and over again, in just the same way. We'll see past adjudication issues more than once during this seminar. You'll see that past adjudication issues include res judicata and collateral estoppel. We will consider each of them in turn. Res judicata is claim preclusion, collateral estoppel is issue preclusion. And once we've got that straight in our heads, the only other issue we really need to be aware of is what parties can be bound by these past adjudication ideas of claim preclusion or issue preclusion. Remember, parties and privies are bound by res judicata, whereas collateral estoppel can be is a sword that can be swung by third parties. Past adjudication is pretty straightforward. But here, possibly more than anywhere else in civil procedure, we really need to do a careful job of factual analysis. And that's about it for civil procedure. It's one of the smaller subjects, certainly smaller than anything we've looked at before. And although it does have a few complex issues, this is straightforward stuff. And as we'll see from the essays, most of the essay questions the examiners present on this topic are similarly straightforward.